Good afternoon. My name is Lisa Collins, UBA's Director of Strategic Solutions. On behalf of United Benefit Advisors and Unum, we welcome you to today's presentation in the UBA Employee Benefit Webinar Series. Today's topic is Practices in Paid Parental Leave. We have with us today Donovan McCann, who has expertise in leave management, specifically the Family and Medical Leave Act and the Americans with Disabilities Act. As Assistant Vice President, Unum Solutions, she combines more than 30 years of employment law experience with practical knowledge of the complexities of leave and accommodation management to create solutions that help employers manage the complex leave process. Currently, she supports Total Leave, Unum's digital leave management solution, and Unum's ADA Assist, which is a simple, secure way to administer ADA accommodation requests. Ellen joined Unum's solution organization in August of 2021 after briefly working for the employment law firm Littler Mendelsohn. Prior to working for Littler, Ellen was Assistant Vice President, Legal Counsel of Unum's Employment Law Group, where she provided legal support to Unum's Absent Management Center and advised HR on all employment-related legal issues for more than 23 years. So we can see we have a real expert here. She worked for a law firm in Boston for several years prior to joining Unum. Ellen graduated from the College of Holy Cross and the University of Notre Dame Law School. So Ellen, I'm going to turn it over to you.
Great. Thank you, Lisa, and thank you to UBA for inviting me to be here today and for everyone who's joining us. I'm really excited to talk to you about one of my favorite topics and a topic that I think is just front of mind for a lot of employers these days, and that is really paid parental leaves. But before we jump into paid parental leaves, I just wanted to talk just a little bit about some of the considerations you may want to keep front and center as you're developing any corporate leave plan, and certainly some of the things you'll want to make sure you're addressing specifically in your leave policies. And these criteria really are not unique to paid parental leaves. They do really span any kind of corporate leave you might be drafting for your employees and for your organization. But what I found in my experience is that a lot of employers want to keep things really simple, and that makes really good sense. But you do want to keep in mind all of these core attributes of a corporate leave program. Make sure you address them in your policy specifically, because when you do that, you really can avoid employee confusion, and you can avoid employee morale issues if they don't have a great leave experience because the policy was unclear and perhaps the employee thought that they would receive a different benefit than what you had intended in the policy. So I won't read through all of these, but really these are the key components to any corporate leave policy that you want to make sure that you address. So addressing things like employee eligibility, of course, you would obviously want to do that, and that would be really something that would be probably in the first sentence or two of your policy. But some of these other topics may not be as obvious to you, like substitution of PTO and other paid leave benefits, coordination with maybe statutory programs. These are all things you're going to want to make sure that you're addressing specifically. And as we go through the program, really, I just want to remind you that all of the information I'm providing you today is not specific legal advice. Always have to give that legal disclaimer at the beginning. This really is information just for informational purposes only. And if you have any specific questions, you really would be best served to consult your own attorney and have them help you through these issues, particularly since most of these issues are pretty complex statutory requirements. So now let's jump right into paid parental leave FAQs. And really, these are all FAQs. These are all issues that I've been asked about by employers. I've taken examples from policies that I've seen that employers have had me review over the many years I've been doing this. And these are things that I see from employers really needing help and guidance in what are best practices surrounding paid parental leave. We know that this really is an area where many employers have gone ahead and executed paid parental leave policies to be competitive. This is a benefit that I've heard some folks describe as almost table stakes these days to have a paid parental leave policy. So if you have either already gone ahead and adopted one, or if you're thinking about it, these are some of the things you'll want to keep in mind as you proceed in developing your plan, or perhaps reviewing your existing plan to make sure that you're keeping in line with some of these best practices. So the first FAQ, or the first question that I hear a lot is, hey, this is my own corporate leave. This is a benefit that I'm developing for my employees. This is not something I'm legally required to do. So I have complete freedom and control over what I can put in my corporate leave policy. Isn't that true? And unfortunately, that is not true. And a lot of employers really start with great intentions, and they want to provide their employees with a wonderful benefit, but they forget that these policies are considered to be terms and conditions of employment and employment benefits. So all of the employment laws that apply to terms and benefits of employment are going to apply to your corporate leave policies. So many of you, I'm sure, are familiar with Title VII. Title VII is the general anti-discrimination policy in the US, which says that employers can't discriminate against their employees who are in protected classifications, such as based on race, color, religion, national origin, age, and a few other factors. So those policies will still, or those laws will still apply, as well as some other federal laws like the ADA or Americans with Disabilities Act, which says employers cannot discriminate against employees based on disability. But what's really important to remember as well is when we're talking about these employment laws, they do not just prohibit intentional discrimination. So those policies that on their face discriminate against certain categories or protected classes of employees. They also prohibit an employer from taking actions which result in an adverse impact to folks in protected classes. And what an adverse impact really means is that someone in a protected class receives less benefit than others who are not in that protected class. So when you're looking at your corporate leaves, you need to make sure they are not only discriminatory on their face or have intentional discrimination policies, but they also do not create this disparate impact against certain categories of employees when they're actually applied to the employees. So let's use an example of this is a pretty obvious policy, but it's a great first example to jump in when we're talking about how Title VII can apply to your policies. So this employer policy provides that female employees receive 4 weeks of caregiver leave to care for ill children or parents. And this is really based on the employer's belief that female employees bear more of the caregiving responsibilities than male employees. And it could even be based on a survey that the employer took of their employees, asking them about their caregiving responsibilities. So this employer thinks that they're doing the right thing, and they have a valid business justification for this policy. However, this policy can be subject to challenge on the basis that it does create a disparate impact. And I would argue it's also on its face facially discriminatory against male employees, because female employees are receiving greater benefits. And it's also based on stereotypes, on gender stereotypes of which categories of employees are caregivers outside of work. So this would be a problematic policy, of course. Next question is, do I have to give male and female employees the same amount of bonding leave? And really this comes down to EEOC guidance, as well as coming back to the foundation of Title VII, which says that male and female employees need to receive equal benefits at work. And so here, when you're looking at bonding policies, what the EEOC has cautioned us in their guidance is that we have to separate the period of recovery from pregnancy from the period of bonding and treat those as two different leave events, which may mean that a birth parent receives a longer amount of paid leave than a non-birth parent, because the birth parent has, of course, the pregnancy disability recovery period that the non-birth parent does not have. And then both parents should receive an equal amount of bonding leave. This is a topic that I probably talk to employers about at least once a week. This is a tricky one because a lot of employers look and just see how much time the employee has out of work. But what EEOC guidance suggests is that we should be looking at the time out of work and what the reason is for the time out of work, separating pregnancy or childbirth recovery from bonding. So an example in this case would be a policy that, in addition to providing medical leave for women with pregnancy-related conditions and for new mothers to recover from childbirth, this employer policy provides 6 additional months of paid leave for new mothers to bond with and care for their babies, but the policy does not provide for any bonding leave for fathers. This policy obviously would be discriminatory on its face because the bonding period of time that this employer is giving to new moms is not giving equally to fathers. So there's gender discrimination based on sex. So let's talk a little bit more about that concept that I just raised in the prior FAQ, and that is what happens if you have a birth parent who has 2 different events that are going on upon the birth of a child. So they have pregnancy, disability, or recovery from childbirth, and then they have bonding leave. A lot of employers want to run these 2 events concurrently. So here again, the EEOC instructs us we need to separate the reason for the leave and consider pregnancy disability leave separate from bonding leave. So let's look at a couple of examples here. And these are examples actually that come right from the EEOC guidance that you can find on the EEOC's website. The first policy involves an employer that gives 12 weeks of paid parental leave. And the period during which the birth mother is recovering from childbirth is included in that 12-week period. This policy can be easily subject to challenge since a birth mother who needs 6 weeks to recover from childbirth only gets 6 weeks of paid bonding leave because the other 6 weeks she's recovering from pregnancy, while a father is entitled to 12 full weeks of paid bonding leave. Let's look at a second example to see how this plays out. Here we have an employer policy that provides that all employees are entitled to 6 weeks of paid bonding leave. For birth mothers, they get this 6-week bonding period in addition to any paid pregnancy disability leave to which they're entitled. So in application, an employee named Sally has a C-section and she receives 8 weeks of STD for recovery from that C-section and then takes 6 weeks of paid bonding leave for a total of 14 weeks of leave. John is another employee who has just had a baby and he is limited to 6 weeks of paid leave upon the birth of his baby. This may look like on its face, it is not compliant because Sally's receiving 14 weeks of leave and John is receiving 6. But what we really have to look at is how much time are they each receiving for bonding? And they're both receiving 6 weeks of paid bonding leave. So this policy, according to the EEOC, is a compliant policy. So what I see is themes that really kind of play off of this same concept, where some employers will actually say, I want to give my birth mothers more time out of work or more time to bond with their children because I just want to support them. It's a tough environment to keep women at work, and I want to have a policy or a benefit that's really generous for those new moms. And I've heard you say I can't give more bonding leave to mothers than fathers. I have to treat them equally based on gender. So why can't I just slide this in and call this recovery from pregnancy or childbirth? You've told me I can give moms time to recover from childbirth. So maybe I can just give them more time to recover from childbirth without any proof that they're actually disabled during that period. So I've seen some employers say, birth moms get 12 weeks to recover from pregnancy, regardless of any medical documentation or regardless of the kind of delivery that they have. This seems to be a trend that I'm seeing lately, where there really is a very generous pregnancy disability policy that is given to birth parents regardless of medical need for that time out. So here, let's look at a policy where all birth parents receive 12 weeks of pregnancy disability under the employer's STD plan without needing to provide any medical documentation and 6 weeks of bonding leave, while non-birth parents are also receiving 6 weeks of bonding leave. Here, even though the amount of bonding identified in the policy is the same, it can be argued that this policy is actually discriminatory because it's providing more bonding leave to the birth parent than the non-birth parent, because there's no requirement that the birth parent actually be incapacitated to receive 12 weeks of STD. And as we know, 12 weeks is not a standard STD recovery period. Now, if this employer said they would give STD recovery upon medical documentation, in fact, they could, and in fact are required to provide STD for the recovery period for the time in which the employee is actually incapacitated by pregnancy, provided they're providing the same benefits to employees who are incapacitated for other temporary disabilities, which are not pregnancy. Next FAQ I want to talk about here is not necessarily in the amount of time that employees have off. So male and female employees may have the same entitlement or the same number of weeks of leave, but some employers want to dictate how the employees take this leave and have different requirements for male and female employees. There's also a risk of gender discrimination here if a policy requires that birth parents take paid parental leave differently than non-birth parents. So let's use an example here to see how this plays out. A policy that requires that birth parents have to take paid parental leave immediately after they conclude their STD period for pregnancy disability, but non-birth parents can take paid parental leave anytime within 1 year of birth would be problematic and may likely be found to be discriminatory because female employees don't have the same flexibility in their terms and conditions of employment as male employees do. So they're told when and how they have to take their paid parental leave, and they lose that flexibility that their male counterparts are able to have with regard to this policy. Next topic is a topic I still hear a lot of questions about. Many of you may have read about a lot of cases that involved primary and secondary caregiver benefits. And in most of the cases that received a lot of attention in the media, these policies were struck down. So a lot of employers come to me and say, hey, I've heard that I can't do this anymore. I can no longer have a policy that has a primary and secondary benefit. And that actually is not true. You can still have a paid parental leave policy that has a primary and secondary benefit. However, you have to be careful that when you set up your policies, you set them up in a way that is non-discriminatory and is not based on gender stereotypes or specific gender rules. That's what happened to the employers that you probably have read about who got in trouble with their primary and secondary caregiver policies. So let's look at this policy. Here, an employer policy provides birth parents with 8 weeks of paid bonding leave and provides non-birth parents with 4 weeks of paid bonding leave. This employer defends its policy based on the argument that it's not gender-based, it's based on birth parent versus non-birth parent, and it's really aimed at combating a trend of female employees not returning to work after having children. However, regardless of what they call this policy, really this policy is subject to challenge, since although it's not gender-based on its face, it does have an adverse impact on male employees, since male employees are, in the vast majority of cases, not birth parents. So the employer can articulate a business justification for this policy, but if litigation were filed, the employer would most likely have to fight this case and may even lose this case because this policy creates an adverse impact on male employees. Second example of a primary and secondary policy involves one where the employer gives 6 weeks of paid bonding leave for primary caregivers and 3 weeks for secondary caregivers. Both male and female employees can be primary caregivers and receive that more generous benefit. But if a male employee applies for primary caregiver benefits, he has to show more proof than his female counterparts. He has to provide proof that either the baby's mother is disabled and can't take care of the baby, or that she's returned to work. A female employee who applies for primary caregiver benefits, however, does not need to submit any documentation. This policy is subject to challenge as discriminatory because male employees have to jump through a lot more hoops than female employees. And it's also based on a gender stereotype of who is the primary caregiver. Many of you may recognize this is similar to the Estee Lauder case, which received a lot of attention. And this was primarily how they were administering their policy, and the EEOC found that discriminatory. Another thing to point out, though, with primary and secondary caregiver policies is even though you can certainly set this up in a compliant way, what I've been seeing lately is a lot of employers are moving away from primary and secondary caregiving distinctions based on negative feedback from their employees who feel that it really isn't fair to categorize employees as primary or secondary. They feel that they have equally important roles in their children's lives. And other employers who found that having these policies may create an environment or a climate where male employees are reluctant to claim primary caregiving status due to the office environment or due to the fact that that's frowned upon. So just some things to think about if you are thinking about primary and secondary policies. Another trend we're seeing in a question we get asked a lot is, can a paid parental leave policy be limited to non-birth parents who are the spouse or committed partner of a birth parent? And this really is another problematic policy and something that's not a best practice, because this will create employee morale issues as biological parents are going to not be able to access paid parental leave if they are a birth father and do not maintain a certain relationship to the birth parent. These policies aren't inclusive, and they may even be challenged as discriminatory, since there may be an adverse impact for male employees. So you may be scratching your head and saying, I'm not quite sure what you're getting at here. So let me tell you an example here and show you how it works. Here, the employer's policy provides 6 weeks of paid parental leave to the birth parent and any employee who is the spouse or committed partner of a birth parent. In this case, a male employee who is a father to a new baby but is not in a committed relationship to the baby's mother will not be able to receive benefits under the policy. Not only is the employee going to view this policy as unfair and not inclusive, but the employee may challenge it on the grounds that it does create an adverse impact to male employees. So I know I'm going through a lot of material here, but I want to make sure we leave plenty of time for Q&A. So I'm going to keep moving along. If my employee is in a state with a statutory paid leave program, paid family and medical leave program, a lot of employers ask this question: do I have to allow the employee to take my paid corporate leave in addition to their statutory benefits, or asked differently, consecutively with those benefits, or can I require them to take them concurrently or at the same time? Typically, employers do have the right to require an employee to take statutory benefits at the same time as or concurrently with a paid corporate leave. One thing you want to make sure is, if this is your intent, is that it's very clear in your policy that employees have to take these benefits at the same time. You want to make sure that's clear, and you always want to make sure you give the employee the right to take their PFML as provided by law. But if they want to go ahead and take that differently, you can then tell them they're not entitled to your corporate paid leave. So let's use an example here. What if you're in a state with a PFML program that allows employees to take bonding leave intermittently in one-day increments? This reminds me a lot of New York PFL. The employer has a paid corporate bonding leave that requires employees to take leave in one continuous block of time and does not allow an employee to take leave in one-day increments. In order to prevent employees from stacking their PFML leave with your corporate leave policy can clearly state that your employees have to file for and receive any PFML benefits in order to be eligible to receive your paid corporate leave, and that the leaves will run concurrently. And you can require your employee to take this leave consecutively or in one block of time. Your employee still has the right to take PFML in 1-day increments if they want to do that, but they would not have the right to take or to receive your corporate paid leave there, because your requirement is that that time is taken in one block or one continuous period of time. Another example of this same concept is that there's a PFML program that provides employees with 12 weeks of bonding leave at 60% income replacement. The employer's paid corporate bonding leave also provides employees with 12 weeks of leave, but provides it at 100% pay. In order to prevent the employee from stacking these two entitlements, the employer's corporate leave policy can clearly state that employees have to file for and receive their statutory benefits in order to be eligible to receive those paid corporate bonding benefits. And the policy can also provide that they will offset from the paid parental leave the maximum amount the employee is going to receive under that PFML program. If an employer wants, and as long as it's clear in their policy, in most states with PFML programs, the employer can also let the employee know that it will take the maximum offset under that PFML program. But if the employee receives less than the maximum amount for whatever reason, the employee can provide the award letter to the employer and can receive additional pay for what it did not receive under the PFML program, but which was offset. So let's talk now about spousal sharing and whether it's best practice to require your employees to share their bonding time under FMLA and then also have to share their paid parental leave. As we know, FMLA does allow employers to require their employees to share their entitlement of FMLA for bonding and to care for an ill parent. This really isn't a best practice in the FMLA world, but it really isn't a best practice when we're talking about your paid parental leave. We've seen that this can create morale issues because unmarried couples do not have to share their FMLA time, and employees do view this spousal sharing rule as a marriage tax. It can also create confusion for the employee because they don't understand why this limit exists or how it's going to work. And lastly, it can create some administrative problems for you as the employer because now you have to track that remaining FMLA time that the employee wasn't allowed to take because of the spousal sharing rule. When you add potentially a paid parental leave that also requires employees to share, spouses to share, it gets even more confusing for the employee and can create even more of a feeling for your employees that there is a marriage tax at play. So we're really seeing this become less and less of a best practice and less employers using spousal sharing for FMLA, but particularly for paid parental leaves. Another question we receive a lot is, should I include adoption in my paid parental leave policy? And this really is a best practice in a lot of places and is also legally required in many states. So check with your counsel if you have a policy that does not include adoption, because many states do say that adopted parents have to be treated like biological parents when it comes to employment benefits. And then, of course, finally, last topic is foster care. So similar question, should I include foster care in my paid parental leave policy? This is also a best practice I've found, and I've seen more and more employers going ahead and including this. But there are some specific nuances to foster care that you will want to make sure you think about when you draft your policy. And so some of the questions you want to answer and make sure they're clearly outlined in your policy are things like, since employees can foster numerous children either at the same time or over time, will there be a limit to how often an employee can take paid parental leave for foster care? Will there be a maximum lifetime entitlement, for instance, or a maximum entitlement over a certain number of years? If the employee later adopts a child that they previously fostered and took paid parental leave for, are you going to allow them to take paid parental leave again? Is there going to be an age limit to fostered children? And if so, will it follow the FMLA age limits for care of a child? So those are really all of the topics I wanted to cover. I'm going to turn it back over to Lisa, who's going to run through some Q&A for us.
So I've got just a couple here. As far as, let's see, this question is basically about policing, how do they get in trouble if they set it up, didn't mean to, discriminatory fines associated with it.
It's a great question. And a lot of employers do wonder, what is the exposure here? And the other thing I found, a lot of employers start to get a little bit uncertain here about what are the fines FMLA fines or are the fines Title VII fines? Typically with a paid parental leave, if you're administering your FMLA correctly, you're not looking at FMLA fines, but you are potentially looking at fines under Title VII. And so under Title VII, the employee can receive back pay, they can receive damages, things like lost benefits, the cost of insurance. And there can also be some not punitive damages, but liquidated damages for those issues that the courts find to be intentional. So it can be pretty significant damages in the Title VII context. Think of it as the same damages that you're familiar with and you would have if you had a policy that discriminated on the basis of race. It would be the same set of damages there, as well as the same reputational risk and potentially the same fines that the company may find themselves subject to.
What are some of the practices you're aware of for employers who are under 50 employees? So FMLA not yet required.
Right, so great question. So again, from an FMLA perspective, if you decide you're going to provide leave to your employees, you would be more likely providing it under a corporate leave of absence. That is a best practice. If you have 15 or more employees, you are governed by Title VII of the Civil Rights Act. So that's going to apply to you. You're also governed by ADA. So that's going to apply to you, as well as state anti-discrimination statutes may apply to you. So you want to be careful you're complying with all of the different requirements, even if you're under 50. Another thing I would suggest, if you're under 50 employees and you're not covered under FMLA, you want to be really careful to not hold yourself out as being covered under FMLA, or not hold your employees out as providing them with FMLA benefits, because the courts may say that you are later prevented or stopped from denying that FMLA applied to you. So you want to be careful. If you're not covered under FMLA, give your employees leave under corporate leave plans. Don't tell them it's FMLA. Don't tell them it's coming out of an FMLA policy, because under FMLA, employers cannot deem an employee eligible for FMLA unless they actually legally are, and cannot cover an absence under FMLA unless it's covered. Where employers get in trouble here is they think they're being generous and it's a great policy, but if that employee does later become FMLA eligible, maybe you grow as an employer and you now are subject to FMLA, that employee still has a full complement or full FMLA entitlement available to them, because you are not legally allowed to take that time away from them before. So work with your counsel on that. Develop those policies that are non-FMLA, but as generous as you want, keeping in mind all of the different employment laws that may still apply to that corporate policy.
Oh, this is complex stuff. So two more, and then we'll probably wrap up with that. We have a PTO policy, so they don't separate sick and vacation. Thinking about implementing a policy where parents would be given 2 weeks extra PTO to be used within 12 months of birth at their discretion. This would be for birth, adoption, foster care. Any concerns on this approach versus separate paid parental leave time?
It's an interesting perspective, and one I honestly don't see a lot of employers following. And I think I don't see it for a couple of reasons. One is that typically when you have a paid parental leave policy, as I mentioned in the very first slide, you can set out all of the parameters that apply just to that policy. When you incorporate this in your PTO plan, all of your PTO plan provisions are likely to apply to this time, as well as any state laws that govern the use of PTO. So as many of you know, in some states, PTO is considered wages. California, Massachusetts, a few other places. So those wage and hour laws will attach to this time if you have it in your PTO policy. So things like, having to pay employees out at termination may attach to this inadvertently. So if you're thinking of doing that, I would work really closely with your wage and hour counsel to make sure that if you're putting it in your PTO policy, you're not inadvertently subjecting yourself to wage and hour laws that govern PTO in the state you're in. You want to really have it ideally in a separate paid parental leave policy. It can be short. It doesn't have to be complicated. It can be one page as long as you cover all of those attributes. But that way there, it's crystal clear that it's not going to be subject to wage and hour laws for PTO. It will just be subject to those policy provisions.
Interesting. And the last question, we always get this is recorded. You can go on our website, the United Benefit Advisors website, listen to the recording. So if you missed anything or want to re-listen to anything, this will be up very shortly. Marketing gets it up very quickly. So with that, thank you, Ellen, so much for sharing your expertise with us today. Thank you to all the UBA partner firm employees and their clients who joined us today as well. We have a webinar coming up. These are monthly webinars. The next one is May 16th, and it's on prescription pharmacy. So how to determine the best pharmacy plan for your health insurance plan, presented by RX Benefits. RX Benefits is another valued UBA alliance. So thank you for participating again in the UBA compliance webinar series this month. Hopefully you'll join us again next month, and we'll see you then. Thank you.